Good afternoon, the Honorable Chief Justice, the Deputy Chief Justice, my lords and my lady, Justices of the Supreme Court. My name is Esther Ang'awa. I'm led by Mr. Nelson Harvey for the first to the fifth respondents. ETOPS, ETOPS. A few days ago, Mr. Harvey told me a plane cannot fly with one engine. I didn't take his word for it. He's not a pilot. So I conferred with Captain Wicks Rabach, a military army captain, and now a commercial airline captain for more than 10 years. He laughed, he said, yeah, it is true, a plane cannot fly on one engine for too long. It's a basic principle. It's ETOPS. Engines turn or passengers swim. Engines turn or passengers swim. That's the informal for extended range twin engine operational performance standards in airline lingo. In short, the ETOPS rule, currently 240 minutes in the US, is the amount of time that a twin engine aircraft is allowed to fly along a flight path that is far from an adequate airport. So that if a two-engine aircraft chooses a flight path that goes beyond 240 minutes, and that's in exceptional circumstances, ordinarily it would be 180 minutes, that's 3 hours, there's a problem. Because should that plane lose one engine, it would not make it to the nearest airport and land safely. Engines turn or passengers swim. It is our submission that the IEBC is a twin engine aircraft. Article 88, sub-article 5. The Commission shall exercise its powers and perform its functions in accordance with the Constitution and national legislation. The two engines of the Commission. In the interest of time, my lords and my ladies, I know you have read and you will continue to read. I will not spend as much time on all the decisions that have been cited to you. But I would like us to use this basic airline principle to understand why this honorable court must interpret Article 88 and Article 250 sub-article 1 in the manner they were interpreted by the Superior Court and the High Court, and not in the manner suggested by the Commission. Composition of the IEBC is at least 3, a maximum of 9. Composition defined in the Chambers Dictionary thus: composition, the act or act of composing. Compose, to form by putting together or being together, to set in order or at rest. The Constitution constitutes the Commission by giving a minimum of 3 and a maximum of 9. In compliance with Article 88(5), Parliament enacted legislation, the IEBC Act, which the second engine set the specific composition of the Commission now at 7. The marginal note in the IEBC Act speaks to composition and appointment. Quorum is relegated to the schedule. Had the drafters of the IEBC Act and even the Constitution intended that the composition of the Commission be equated to its quorum, nothing would have stopped them from doing so in the Constitution or in the section that provided for the composition of the Commission in the IEBC Act. This is the definition of quorum. The legal definition of quorum under the Black's Law Dictionary, I'm referring from the 9th edition. Quorum is defined thus: in parliamentary law, the minimum number of members, usually a majority of all the members, who must be present for a deliberative assembly to legally transact business. That is the definition of quorum. Now, what is the definition of majority? This is the definition of majority under the Black's Law Dictionary: the status of one who has attained the age of 18, the relevant definition being the second, a number that is more than half of a total, a group of more than 50%. A majority always refers to more than half of some defined or assumed set. So that if this court were to be convinced to follow the request by Professor Githumuigai, that where the paragraph on quorum is deleted, we must go back to the Constitution and rely only on the Constitution, our one engine for the Commission, because the second engine has failed. The Constitution sets a minimum of 3. He says, on behalf of the Commission, that they can go ahead and conduct business. Would quorum with a membership of 3 be 3? Based on the definition I have read to the court, absolutely not. A majority of all the members being 3 would be 2 commissioners. Now, I would urge the court to read paragraph 77, 74 to 77 of the judgment of Justice Chacha Mwita when he was dealing with that conundrum, because then the quorum had been reduced to 3, and he was looking at those provisions that had reduced the quorum to 3, and saying then, with a membership of 3, because then the Commission had only 3 members present, 4 having resigned. Would a legally binding decision of the Commission be made by the majority, being 2 commissioners? And what effect would that have on the performance of the Commission in its objects as stated in the Constitution and in the IEBC Act, Section 3, subsection C, 3C, 31C? And the basis of the judge in holding that that amendment, reducing quorum to 3, was unconstitutional. And a similar amendment to paragraph 7, which said that should the commission fail to reach a unanimous decision, then the decision of a majority of the members present and voting would bind the commission, which paragraph was also deleted. Meaning now that one engine has completely failed. Even if we were to say that the commission has 3 commissioners and is properly composed, as according to the Constitution, what happens where a unanimous decision cannot be reached by the commission? Would the commission make legally binding decisions by its majority of 2? Justice Okwany saved the commission, qualifying the reason for doing so by creating a dichotomy between what she considered a policy issue and routine administrative issues that the commission did not need commissioners to make decisions based upon. And that is the only reason that the judge gave for allowing the by-elections which were in issue to proceed. But that judge, including the judges of the High Court and the judges of the Court of Appeal, decried the failure to replace the commissioners who had resigned. And that is where the extended range comes in. The period provided under the IEBC Act, our twin engine, is that, look, the commission, our twin engine aircraft, has lost 1 engine and needs to get to the nearest airport to land. Otherwise, passengers swim. And so the court, in its wisdom then, allowed the commission the comfort to proceed. I believe in the hope that the provisions of the IEBC Act relating to replacement of the commissioners would be followed and the appointments would be made. That was not to happen. Now, my lords and my ladies, you have been told to ignore the fact that no appointment were made until over 4 years later. The plane crashed because the second engine, the Constitution, could not get the IEBC to the nearest airport for landing. The IEBC is now fully constituted. And it is my view that that is probably because of the determination by the High Court relating to the invalidation of the administrative procedures that it sought to rely on, which were made without it having all its commissioners on board. Were that not to happen, who knows? We would be flying straight towards a general election with 1 engine nearly dying. I urge this court not to unsettle the holding of the Court of Appeal. And most importantly, because that holding relates to an invalidation of the administrative procedures, and if the court allows me, I would like to read it. This is what the holding of the High Court was. A declaration is hereby made that the administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null, and void because they were made without quorum, in the absence of legal authority and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Uphold that declaration, my lords and my ladies. Because what is in challenge here is that declaration, not the decision of Justice Chacha Mwita. This is the holding of the Court of Appeal that touches on quorum. The Independent Electoral and Boundaries Commission does not have the requisite quorum for the purposes of carrying out its business relating to the conduct of the proposed referendum, including verification whether the initiative as submitted by the Building Bridges Secretariat is supported by the requisite number of registered voters in accordance with Article 257(4) of the Constitution. The IEBC has told you, if you cannot disturb the findings of quorum, if you cannot disturb the findings on quorum, then please circumscribe all the actions by the Commission prior to the making of the determination by the Court of Appeal. With all due respect, my ladies and my lords, we do not know what those actions are. Those actions have not been challenged before any court, at least not within our knowledge, and not within the court's knowledge. What actions are these? Where have they been challenged? And as His Lordship, Justice Tuyot said, this decision the declarations take effect at the date of judgment. I have indicated that what has been invalidated by the Court of Appeal on the basis of quorum is the administrative procedures and all the acts relating to the referendum. There is no basis upon which this court can protect certain actions that we haven't been told about. I urge you dismiss.